Good morning. Thank you for joining Lewis Rhodes and myself. My name is Merrick Green. I'm the managing partner of the law firm General Counsel PC. Lewis leads our government contracts practice. Thank you for joining us today for bid protest, when, where, and can you win? So without further ado, let's get going. If you have any questions during the presentation, please use the questions tab and we will answer those throughout the presentation. Do not wait till the end. We'd like to make this as interactive as possible for the attendees. So just quickly, a little overview about General Counsel. We were founded in 2014, so we're a little over 16 years old now. And as the name implies, we serve as outside general counsel to many small, medium-sized businesses throughout the DC metropolitan area, and also represent their interests throughout the US in a number of matters. And being here in the DC area, we represent a lot of government contractors. So hence why we are here today. We have 5 primary practice areas: corporate M&A, that's everything from buying and selling companies to working on contracts and everything in between. We're representing companies in labor employment law matters, government contracts, obviously, litigation in state federal courts throughout the DC area, and also arbitration and mediation. And then we recently also added a family law practice. A little bio about Lewis, and this is also on our website, but we are pleased to have Lewis join us probably a little over a year ago. Lewis has been practicing government contracts law probably for, Lewis, 18, 19 years, give or take.
Give or take. Yeah, it's long enough that I don't like to admit how long it's been.
Yes, he has the gray hair to admit it, and looks like it's getting whiter and whiter on the chin. But he has both experience working within law firms for the first 10 years of his legal career, and then he also spent about 7 or 8 years in-house. So he really has that experience working with businesses, preparing the bids, dealing with bid protest, and everything else you have as an in-house attorney. And then it also says at the bottom, he's a lieutenant colonel, still active in the reserves, and it's a service-disabled vet with multiple combat tours. So, Lewis, from there, I'm going to go ahead and turn it over to you. And please, as we go forward, please ask any questions.
Okay, thank you, Merritt. And then one thing I will, I will stress on my background when it comes to bid protests and other matters is, unlike a lot of bid protest attorneys who've been out in law firms, I've actually rolled up my sleeves and written proposals. So I understand the soup to nuts aspect of it, having to put together teams, build your staffing, price it out the right way, and get it out there. Especially when it comes to looking through pricing sheets and understanding that, I think I've been able to make a few bid protest arguments lately that my understanding of the finances and pricing and the P&Ls around a proposal helped a lot. So it's nice to have a broad experience. Now, before we get into the topics, I want to call your attention to this great resource that our firm sponsors called Bid Protest Weekly. It's a repository of bid protest case digest organized by keywords. It's been out there for like almost 15 years. It's got hundreds, if not over 1,000 digested cases where you can kind of see what GAO's case law is on protests. It's a great resource if you just are curious and you want to say, hey, something doesn't sound right. You go up there and take a quick look around. We endeavor to push out a new article on another case every 2 weeks or so. Sometimes events overtake us, but we have a nice steady stream we're adding out there, and you can get registered to get our updates as we push them out every couple of weeks.
Yes, so, we were very optimistic when we named it to be the weekly, and it's probably better the bi-weekly and occasionally monthly. But it still does have thousands of summaries And the searchable database is incredible with over keywords. So if you have any sort of bid protest issue, you can put in the keyword and find decisions on those matters. So it's a great resource.
And the good thing about GAO too is the laws and rules very rarely change. I mean, I've seen very minimal, when you get to protests, you get to your main grounds and your main arguments for protest, they're all factually driven. So a lot of the laws and regs, even if you find an opinion from 1995, it's probably still good law. So now diving into bid protest specifically, so a bid protest by definition, right, here's the legal definition. You have a written objection by an interested party to an action by the federal government, a procurement action. So the government makes a decision to award a contract, to issue an RFP, to not set it aside for a small business, a whole host of things that are considered procurement activities, right? That's not just my award decision. As you see, we go through here, there's a lot of steps in the process. Any one of those where there's a decision trigger point and the government does something that you think is wrong, that's where you can file your written protest. All right. Protest can be pre-award or post-award. Pre-award is something I beat the drum on a lot. I've given a webinar about 4 times on that over the past 12 months. I still have clients who come to me with issues. I just spoke to a client on a protest the other day, and the opportunity probably was improperly bundled, and there would have been a really good pre-award protest. But because you didn't protest timely, you can't raise that issue now. So I'll talk about it a little bit here. You can go on our website and find the webinar I gave on pre-award protests. It continues to vex me that a lot of my clients lose good arguments because they don't bring them timely on the pre-award side.
Lewis, how do you know when to do that? Hopefully our clients are all well trained enough that they will contact you anytime they have an issue. Whenever something doesn't smell right, lots of times it's, potential clients calling us and saying, this happened a month ago, I didn't think about it, and I just lost the bid. What can I do now? And your answer is, sorry, nothing.
Yeah, and that's a hard conversation to have, and I hate it. Bid protest is, we'll talk about it in a little bit, is very, very draconian in its timelines. If you're challenging something in the solicitation, you have to bring it before you submit your bid. Up to and including, if bids are due at 4 p.m. on a Tuesday, you need to have your protest filed by 3:59 p.m. On that Tuesday. Otherwise, if you file it at 4:01, it's untimely. And and this is something, when I was in-house, I read every single RFP that we were going after to make sure there wasn't something a little bit funky in the evaluation criteria or somewhere else where there was a potential for a pre-award. And I still do that for some clients now. I'm like, if you see something in your solicitation that just doesn't look right, doesn't pass the smell test, your industry, it's a good time to reach out to someone to put an eye on it and figure out if you have a protest ground.
Or maybe the government agency is sort of targeting it towards a particular company, giving them a softball that, so perhaps the other clients or companies don't have as equal a playing field.
Yeah, the government wouldn't do that ever. They wouldn't try to steal an opportunity to an incumbent or somebody they like, which obviously we all know is tongue in cheek because they do that a lot. And if you're doing good capture, there's a fine line between good capture and crossing the line, right? So, but we'll talk about that a little bit here in a couple of slides. Next slide, please. There we go. All right, so the key on a bid protest is you have to be an interested party. You have to be, if it's a pre-award protest, you have to be eligible to bid. So if it's set aside for a woman-owned small business and you're not a woman-owned small business, you're not an interested party. If it's a small business set aside and you're not a small business, you're not an interested party. So you have to be able to bid for a pre-award protest. There's some case law out there that if you file your protest but don't submit a bid, you can be kicked for not being an actual prospective bidder. So I've always tell my clients, just in case, always submit your proposal, even if you're going to do the pre-award protest. Now, if you file the pre-award protest far enough in advance, you're not in that deadline. But if we're bumping up against the deadline, you still want to get your proposal in. For a post-award protest, you have to have an economic interest affected by the award. Now, what's that mean? It means if you bid and you were 9th in price and all 8 companies in front of you were rated as good or better than you are, you're not gonna have standing to bring a protest. The agency is going to move to dismiss you. You have to have a reasonable chance of winning the award if the protest is sustained. That doesn't mean you have to be second, depending on your protest grounds. It usually helps to be second. And frankly, I tell a lot of clients, if you're 3rd or 4th on the list, you may not want to spend the money to protest, because all you're going to do is help win it for somebody else.
Lewis, how does the company know where they are, whether they're 2nd, 3rd, or 9th?
Sometimes in your debrief, you'll get exactly kind of where you stand. You'll also hear, and we'll talk about debriefs in a little bit. And, I get crazy with the government because they try to withhold information, and that leads to more protests instead of less. But if you look at an awardee who's substantially cheaper than you, one way or another, there's a good sign there may be other companies in between. And the government sometimes will give you at least an idea. And believe me, they'll let you know if you file a protest right away if you're way down on the list, because they're going to try to get your protest dismissed.
Is this one reason why you need an attorney involved? Because attorneys will have more access to this information?
Once your protest is filed, you will. You generally don't have any more pre-filing than your client would have. Once the protest is filed and you get into the record, you see all the unredacted information. But at this stage, you don't. But this is a good time to talk to an attorney, because odds are I've done a lot more bid protests than any individual company out there has done. So just having seen a whole bunch of different protests and arguments and opportunities, you have a little bit broader depth when you're looking at stuff to figure out whether it's worth protesting or not. And this is, any good protest attorney will tell you, whether or not you have a protest grounds. If you come to me and you want to protest, I'm going to tell you if I think you're going to lose. I don't want to necessarily bring a case for you that is going to end up with a bad result and you're going to be unhappy. So I'd rather have an unhappy conversation with you up front and explain whether or not you have a good argument, and then we can make a decision from there. So when you file a protest, you have a couple different venue options. First one is an agency level protest. I used to say all the time that an agency level protest is not worth the paper it's printed on. Of course, we don't print things anymore, but still, they're not the best venue. They're not usually my first choice, but they're more reliable. They're more dependable today, and they have a better outcome today than they did 5 and 10 years ago. Certain agencies, like there's certain agencies in the Army where when you file an agency level protest, because by law, the agency level protest has to go to the contracting officer. So the same person who already picked somebody over you, then you have to protest that person's decision to that person. Okay, that you can understand why that's not always successful. But the Army, they have a special way to do an agency level protest that goes to attorneys within the agency, but outside of the contracting officer. And I've had some success there fairly recently. Back late in 2020, with one of our clients, we filed a agency level protest because we thought the agency was out of its mind awarding a contract to a company that had $100 million judgment levied against it. And the agency took corrective action and took away the award. So that was a perfect example of when you go to the agency, because frankly, the agency's error was so egregious. We took the tact of, hey, we're going to tell you guys something before we embarrass you publicly at GAO. And actually, I think it played well within the agency. So next choice, and what everyone talks about, is GAO protests. I'd say probably 85, if not 95% of all bid protests are filed at GAO. Government Accountability Office. And you go right to GAO. There's a whole set of laws and regulations. It's regulatory, which is why the deadlines are pretty strict. But it's GAO's job. All right, GAO is fairly inexpensive to bring a protest, but you definitely are going to want to have a lawyer, especially as we start talking about protective orders and procurement sensitive information. So if I'm your attorney and I'm representing you at GAO, I get to see the whole procurement file, including the proposal written by your competitors. Okay, I can't share that with you. I can discuss, some issues about it with you, but I can't give you any specifics. If you bring a protest on your own, you don't see any of that. You don't see how the government did its evaluation. You don't get to see the other proposals. So you're a little bit flying blind.
Lewis, is that the same rule for in-house attorneys, or is it? Do they can they also have the access to information as outside?
Yeah. No, actually, it is the same rule for in-house, and it was maddeningly frustrating when I was an in-house attorney and I couldn't do the protest myself because, and this is going back where writing the proposals was, it helps me now, but it didn't help me then. Because, I, as somebody who was in the company, I would see competitors' bids and prices and how they did it. Any government contractor would tell you that stuff is like the recipe for Coca-Cola. You don't want to share it out there. So even as an in-house, you're not allowed to get under a protective order. GAO protests are generally more, we can go back 1 second real quick. GAO protests are generally more effective than most people think. Over the course of several years, 45% of protests are successful. Now, what's that mean? That doesn't mean they're all sustained. Generally, when the government's caught with his hand in the cookie jar and does something wrong, they will take corrective action. So, and a lot of times you'll file a protest and the government will take corrective action within a matter of days. So when you take all the corrective action protests as well as all the sustained protests, you usually are above 45%. And in fact, in 2020, it was about 50%. So you literally were going to win one way or some type of relief every other protest. So given the amount of time and effort that you put in and money to bid an opportunity, a 50% success rate on a protest is worth taking a shot at it. So the other thing that's good about GAO protests is they have a very strict timeline. You will get an opinion within 100 days of when you file your protest. So, just over 3 months, it'll be resolved. Obviously, if you've ever been involved in litigation, nothing gets resolved in 3 months. So GAO is a little bit quick. Court of Federal Claims sometimes can be quicker, but it's more complex and more expensive. But the GAO is 100 days. So Court of Federal Claims is the other big venue for protest. Very few people go to the Court of Federal Claims right off the bat. There's a couple instances where you would. There was an issue I was discussing with a client a couple months ago. They submitted a bid. The government server lost the bid. And the government said, well, too bad, it's your fault, you didn't follow up. Well, GAO has said that, they will find that the government's right. If your bid is lost on their server, you can't protest it at GAO. Court of Federal Claims has a different outcome. Court of Federal Claims says if you got it to the government in the government's control, then it's on the government that it never got delivered properly. So that's an example where the substantive law is different. That's a rarity. Normally people go to the Court of Federal Claims either after they lose at GAO. It's not really an appeal. It's a whole new protest, but you get to go to the Court of Federal Claims, and you have a 1-year time period to go to the Court of Federal Claims. So you can go after, you can go, if you miss your deadline at GAO, you can still go to the court. And that's how a lot of people end up at the court. Now, the problem, the Court of Federal Claims, I mean, this is a court, and it's not as streamlined. You have to write a full-on complaint. It's similar to GAO in that it's all motions practice for the most part. but it's just more elaborate. Your complaint is more difficult than a protest letter. DOJ itself gets involved instead of the agency counsel, and it just becomes a little more elaborate. I would never send a client to the Court of Federal Claims as a first choice unless there was a good reason, like a substantive law or we missed a deadline.
Lewis, do you have some of the same administrative things that you do at Court of Federal Claims? So do you have the automatic stay? Do you have only the attorney can review the materials, et cetera?
There is a protective order. There is not an automatic stay per se at Court of Federal Claims, but you basically file a motion for a stay, and the government has to argue against it, and the court generally leans towards granting it. The government has to show why, they have to show a compelling interest not to grant the stay. But that's the, so it's not I wouldn't say automatic. I would say normally it's given. Now, the Court of Federal Claims sometimes is faster just because, depending on the docket and the argument and the level of the record, but there's no guarantee that it's going to be faster. But even if it is faster, the Court of Federal Claims protest will probably cost you 2 to 3 times as much in legal fees because it's a lot more convoluted. Next slide, please. All right, so again, GAO is the most common. It's inexpensive. It's fast. And you get an automatic stay. So when I go to Court of Federal Claims, I got to file a complaint, then I got to file a motion to get a stay, then I got to argue the motion, right? So that's 3 steps. That's that's an extra 8 to 10 hours of legal work. If I file my bid protest in time at GAO, I put a sentence in my a big bolded sentence in my protest letter that says, under the Competition and Contracting Act, we request a stay of performance, and it's automatically granted. So, it makes it simple and easy. It stops the whole process while you're going. Now, a pre-award protest automatically triggers a stay without you even having to ask for it. They can't, by law, by the GAO regulations, they can't issue an award if you filed a pre-award protest. So again, GAO protests, the big benefit is it's quick, it's streamlined, it's easy, and it's cheapest. And to show you just how streamlined it can be, one time I had a client call me at 10 a.m. on a morning. Their protest had to be filed by 4 p.m. that afternoon, and I was able to get the protest filed. Okay, so in a matter of 6 hours from my first phone call with the client, I was able to get a protest in. I don't recommend that often because you're not going to get your best arguments put forward. We did get a corrective action, and they did cancel the award, but it was, that was a bit. That's why I have less hair today dealing with stuff like that. So you can turn around if you come to me in a short timeline, I can get a protest filed. I would recommend giving me a day, but if you come to me in a day or two, we can get a protest in and file timely. GAO is pretty quick. Now the protest timeline, right? It's a 0 to 100 days. You'll get a decision by day 100, and that's statutory. So they don't have an option to say, well, I'm really busy, I'll get you my opinion next week, right? That's the difference between GAO and a court. So you scramble a lot up front to file your protest and beat your timelines and get everything in, and then you have 30 days while you wait for the agency to produce its record. So a lot of times clients are like, go, scramble, you file, and then you twiddle your thumbs for a bit because you're waiting for the agency report. And again, the agency report is, and this is where and why you need an attorney. The agency report will have the whole procurement file that's relevant to the protest, which will include how you're evaluated by the government, which will include how the awardee is evaluated by the government. It could include the awardee's proposal. It'll include prices. There's a whole bunch of stuff out there that if you don't have an outside counsel under a protective order, you don't see any of that stuff. And this is where your money is made on a protest. You don't win your protest with your protest letter. You get your protest started with your protest letter. You win your protest when you look at the record and you file your comments on the record. You have 10 days to review the whole record, pull everything together, and file what's called comments on the administrative record, which is basically a legal brief pointing out where the government did things wrong and supporting your protest arguments. The other thing that often happens during the review of the record is you find a supplemental protest ground. And I just went through that on another protest. I got a record. We made protest grounds. I got the record. I looked through it, and I realized that the agency called somebody a major subcontractor when they weren't bid with enough hours. You know, they're supposed to do 20% of the work. They were only bid at like 16% of the work on the work proposal. So, you know, that was an additional supplemental protest ground that I brought with my comments. But that's where, like I said, and the other thing, when you review the record is I will call you when I review the record, and if I tell you, I will tell you if I think the protest is gonna be a loser. Because a lot of times we file our protest letter based on things we think happened. We get the record and now we know what did happen. And a lot of times what we think happened isn't exactly what did happen, and the agency, I almost said Army because I fight with them all the time, but the agency did the right thing. And, you know, and I'll tell a client at that point in time, hey, listen, I don't think we're going to win the protest. I recommend that we withdraw it. And, you know, you can withdraw it at that point in time on a review of the record. I think it buys you some credibility with the agency. If the agency says, hey, I'm going to protest, hey, now that I see what you did, I'm going to admit that you were right, I was wrong, and I'm going to walk away. And more importantly, it saves you 10 to 15 hours of legal fees. You know, I don't want to go, I'm not a big fan of advancing arguments that I don't think are going to win. I will if you tell me to, but, you know, I like to tell my clients a fair assessment of where we stand. And, you know, there's been many times we've got to the record and I've called my client and said, hey, I think we should withdraw the protest. Here's what really happens. And I don't think we're going to win. You know, sometimes the client's like, well, you know, you're telling me I got a chance, and we'll push forward if it's a 2% chance. But a lot of times clients appreciate the honesty and are happy to pull back a case that's going to, most likely going to be a loser. Well, once you file your comments, then GAO sits around for 60 days, waiting to issue its opinion. If there's a supplemental protest, there'll be another briefing from the agency, and then you get to file another set of comments. The good news is, even if I file a supplemental protest, it does not extend the 100-day stay. So they still have, I can file 3 supplemental protests, and GAO still has to resolve it on 100 days from day 1. So, and that next slide, please. All right, so GAO protest. You heard me say a couple of times, the rules are draconian. If you miss by a matter of hours, you're toast. Okay, it's not like you can go to court and ask for can you toll this timeline? Can you do that? It's you either make the 10-day deadline or you don't. All right, so 10 days within your notice of contract award or exclusion from the competitive range. When you know you have 10 days from when you learn about your protest grounds to be timely. Okay, you have 5 days from the close of your debriefing or enhanced debriefing. All right, debriefings are under FAR, and note the italicized and bold here, because here's an issue that comes up a lot. You only are required to get a debriefing under FAR Part 15. If you were under FAR Part 8, and that's GSA schedules or something bought through the GSA schedule, you don't get a debriefing. So you can ask for a debriefing, but you don't get one. You can get a brief explanation, but that's different than a debrief, and there's no timelines requiring a debrief. So the government likes to play a game when you ask for a debrief under a FAR Part 8 opportunity. You'll find out on day 1 that you lost the award. You'll ask for a debrief, and then the Army or the agency will, I keep pinging the poor Army. the agency will wait till about 9 days later and tell you don't rate a debrief, and how they just ran out the clock on you and you've lost your protest opportunity. So pay very, very close attention to what FAR part is under it. Even if you're doing a BPA under the GSA schedule that looks like a FAR Part 15 award, where there's a submission and a best value determination and all that other stuff, I will guarantee you somewhere in your solicitation, it will say this opportunity is being solicited under FAR Part 8, which means no mandatory debrief. So pay very close attention to that, and don't let the agency run out the clock on you.
Lewis,
Now,
if the contractor is eligible to have a debrief, do you always recommend that they try to get one?
You absolutely always need to get a debrief. You should even ask for a debrief if you win, because the whole purpose of a debrief is to give you feedback to help you make your next proposal better. Here's what you did wrong. And a very good debrief will focus on that, and the government will give you a lot of information. I get very frustrated with the government because they look at, the more information I give you, the more likely you are going to protest me. So I'm going to keep all my cards to my chest and not tell you. And I've tried to explain to contracting officers and agency counsel repeatedly, the more you show me, the more I know, the less likely I am to protest. But if you're withholding information, I'm going to assume there's a reason you don't want to share the information with me, and I'm going to assume I have a protest ground. So if you tell me everything and you say, hey, here's everything we did and here's why you lost, and I look at that, I'm like, all right, yeah, I just screwed that up in my proposal. You know, you take that as a lesson learned, and you make a better, and you write a better proposal next time. You know, but if the government keeps information to itself, you just assume that they have something to hide and you file a protest.
When you're working with general counsel clients, do you normally help them prepare for the debrief? Do you normally go to the debrief with them? What's the recommendation in that regard?
I encourage clients to come to me as soon as they find out they lost, because you're allowed to submit questions with your debrief, and especially with an enhanced debrief. If you come to me and say, hey, you show me the solicitation, you show me the notice of award, we talk about it, I can help you write questions to ask for the government in your debrief. Now, I can attend a debrief. Any attorney can attend. I sat in on all my debriefs, all the debriefs when I was an in-house counsel. You just need to let the government know that you're going to have counsel at the debrief, because then they bring agency counsel as well. It doesn't mean, you know, anything other than, hey, I just want my counsel to be here. And, you know, like I said, when I was in-house, I sat in on every single debrief because I was helping write proposals. And a good debrief is worth its weight in gold. And I wish the government gave more of them. Now, the enhanced debriefing procedures are, you know, they're not as, you know, they're new in the big scheme of things, but they're a couple years old. That's you know, under the DOD and a couple other agencies have adopted it. After you have your debrief, you can write a second set of questions asking for further detail from the debrief to the agency. And that is where you really should get your counsel involved, because when I have the opportunity, I use enhanced debriefing questions to help shape my protest arguments, because I'll have an idea of what I'm going to want to protest. So I'll ask a question, and depending on how the agency answers, I may get some good information to file a protest. So, you know, definitely reach out if you have an enhanced debriefing. Help get your questions written and get ready to go. And plus, it gives your attorney a little more time to put things together, because your protest clock starts running at the close of your debriefing. So if you're enhanced, you have a debrief, you submit your enhanced debriefing questions. The government has a timeline on when they have to respond to your questions. When you get the response from the government, your protest clock starts ticking. So one mistake actually was a pretty well publicized GAO opinion. One company made the mistake of going back and forth with the government after it got its enhanced debrief questions. The protest, and then their protest was untimely. So the protest clock starts running when they hit send on your enhanced debrief questions. If you ask a second and third round of questions, that doesn't push your clock back any. You're still on your clock running from the first series of questions. So again, this stuff gets a little convoluted, and this is why, I always tell clients, pick up the phone and call me. You never want to miss a deadline and lose a decent protest argument because you miss deadlines. Because if you're 10 days and 6 hours, you're going to be thrown out as untimely. So, and again, we talk about pre-award protest before you file your proposal. Next slide, please. All right, here's a list of some kind of possible protest grounds, right? Normally it's, hey, they didn't evaluate me correctly for my technical or price evaluation. Hey, I'm looking at this and the RFP required X and Y. The RFP required CMMI level 3 and the proposed awardee doesn't have CMMI level 3. You relax the standards. Or, you needed to have X number experience, they didn't have it. Failure to follow stated evaluation criteria is a big one, or undisclosed evaluation criteria. Hey, I'm going to judge you on, the number of people that you bid, but then I don't tell you I'm going to judge you by, the amount of advanced degrees that those people have. All right, that would be an undisclosed evaluation criteria. Or hey, I need 10 engineers in this bid, and the awardee only bids 8. Right? That's a failure to follow the stated evaluation criteria. I recently filed a protest for a client. He was told that you don't have the 5 years of experience required in the transportation industry. Well, when I read the solicitation, it doesn't say anything in the solicitation anywhere about needing 5 years of experience in the transportation industry. All the solicitation said was that your past performance had to be done within 5 years. So it looked to me like the government misread its own evaluation criteria. Improper cost technical trade-off is another big one. That's in your best value, right? When under a best value procurement, I can pick a more expensive offer, right? Maybe you bid $2 million and they award it to somebody who bid $2.3 million. The agency has to justify why they're spending $300,000 of the taxpayers' money. And if they don't justify it and they don't document it, then that's a winnable protest 99 times out of 100. Improper discussions is a big one. This is why the agency and the contracting officer are so nervous about talking to you during the proposal stuff. Right? Because they don't want to be accused of giving one company information and discussions that they're not having with another company. And sometimes it's hard because, when you're on the phone with someone and they ask you a question, it comes up and it's hard to avoid the discussion issue, which is why a lot of those are handled via emails and letters. And then, organizational personal conflicts of interest. That comes up. It used to come up a lot when OCIs were kind of new and hot about 12 years ago. You still see it occasionally. And, if your company has some access to information that other companies don't have, that's an OCI and that's a protest ground. So this isn't all encompassing. These are just probably some of the most common ones.
And if I can, just a quick plug back to the Bid Protest Weekly website. One, through the keyword database, you can search all of these and find multiple decisions and summaries talking about each of these. So if you think that you might have submitted a bid and there was a failure to follow stated evaluation criteria, you can search that within the Bid Protest Weekly, click on that keyword, and find 5, 10, 15 decisions that were based on that grounds, both sustaining or perhaps denying protest. So it really is a valuable resource. And we also have a few educational articles there. So with that, I will.
Next slide. All right, so here's where you can't go to GAO, right? If you're a subcontractor and your prime won't protest, you can't protest. You can't challenge contract administrative issues. If the awardee proposed something that's about how they're going to perform the administration on the contract, that's not a protest ground. Substitution of proposed personnel is in there, but if it's a key person who is reliant on the award decision, right? If my competition bid, the most important person in this entire field, but then that person's not going to be who performs, that's protestable. But if it's not a key person and they're just changing their PM who wasn't a key, you can't really challenge that. Small business issues across the board. All right, if you're gonna make a size challenge or a small business certification challenge, there is a venue to protest that. That goes to SBA. And those protests are a piece of cake to bring. And I would, if you called me and said I want to protest someone as not being an SDVO or a hub zone, I would likely tell you not to waste your money hiring me. You can send a one-page letter to the SBA, to the contracting officer who has to send it to the SBA, and you get the protest. Now, if you're protested on that ground, I would say absolutely call me so we can make sure you keep your award. I just helped the client win a hub zone protest. They were protested for not being a hub zone. It went to SBA. You get a letter from your contracting officer saying, hey, you were protested, and you need to file a response with the SBA who will determine it. So don't bring your small business issues to GAO, but you do bring them to SBA. And I will tell you, hub zone protests can be very successful because there's a lot of companies up there that screw up their hub zone stuff a lot. And again, certifications, if somebody wins an SDVO SB set aside, but they're not an SDVO SB, you bring that, even though SDVOs are rated by the VA, you still bring that issue to the SBA. All right, untimely protests, so jump up and down, bold and italics, right? If you're not on time, GAO will kick your protest in a heartbeat. Okay, and then responsibility under Part 9, that's a small business responsibility determination, which again is an SBA issue, not a GAO issue. So there's a lot of things that look and smell like GAO protests, but they have to be brought to the SBA. Again, there's timelines, so we need to make sure that we're sticking to those timelines. So, this is why, you want to call and at least have a conversation with an attorney to make sure you're going to the right place.
And as we continue forward, it's tough for Lewis not to tell war stories periodically, but I'm going to say that we have about 17 minutes left, so we might accelerate a little bit.
Well, the war stories are the fun part. Again, when should I protest before award? If you think the solicitation is messed up and there's something wrong in that, you need to protest the terms of the solicitation. If you're removed from the competitive range or there's other multiple steps in the process, you need to do those as pre-award protests. I'm not going to go into depth in this. I've got a couple hours of pre-award protest issues recorded out there that you can find on our website. Next slide, please. Again, pre-award protest, signs the fix are in, right? Anything, things that favor the incumbent. I'm going to ask you to do IT help desk, and I'm not going to tell you how many trouble tickets I get on an annual basis. I'm not going to tell you what operating systems I have or how many users, right? You can't scope that bid, so the incumbent can because they know all the information. Anything that makes it look impossible for you to submit a smart bid is a good sign that the RFP is wired and needs to be challenged. So those again are all pre-award protest issues. Next slide, please. Okay, now intervening is the other big one. All right, so if you win an award and someone protests, you want to intervene. You have a right to intervene as the proposed awardee. You always want to intervene, even if you're not going to do a lot, just to make sure that the Army, I fight with the Army a lot if you can't tell. You always want to make sure that the agency is doing the job defending the award. Remember, the agency's interests and your interest as the awardee are not always the same. The agency generally wants to keep the award. They made the decision, they want to defend their actions, but that doesn't mean that they always have your best interest in heart. You always want to get an attorney who intervenes for you and can watch from. I intervene a lot and I just watch, and I let the agency do all the work, and I file a two-sentence filing that says everything the agency said is right, and that's it. All right, and it's literally, it literally adds up to a couple hours of my time from beginning to the end. But it's just a way for me to hover in the background and make sure the agency doesn't screw it up. There's other times where, you may have a protester who hires a law firm that's got 9 attorneys, and the agency counsel is all by themselves, and maybe they have one first-year attorney who's helping them, and they can just get buried in paperwork and overwhelmed. So I've come in as an intervener, and I've helped draft the agency's arguments, and I've done research for them to help defend the award. Oftentimes the agency, if they're a little bit overwhelmed, is very happy to have the help. So, it's basically the awardee offering up some resources to help the government defend the award. So you always want to intervene, and the scope of intervention is going to depend on how the protest plays out and how competent agency counsel is. If agency counsel is good and the protest is weak, you just watch and make sure it plays out the way it should. If the protest is a little more touch and go, you want to have you want to intervene a little more substantively. So I always tell my clients you want to intervene just to make sure. If you work so hard to win an award, you don't want to lose it. So, okay. GAO protest, you file with EPDS. You within 24 hours, GAO will tell the contracting officer of the protest and trigger the automatic SECA stay. All right, the protest will go through the whole process through the GAO's procurement law group. All right, the government will have its opportunity to defend the award decision. But at the end of the day, GAO has to give you a detailed statement if they reach a final conclusion. If you're dismissed for one reason or another, usually on timeliness grounds, or usually agencies are getting a lot more aggressive in moving to dismiss protests for being completely speculative, where you're making a bunch of, the government might have done X, Y, and Z, and if they did do X, Y, and Z, then I was prejudiced and I should get a protest. Nowadays, agencies will challenge protests like that and are probably about half the time they're able to get speculative protests dismissed. If you're dismissed, you don't get a full legal opinion. If you go all the way to the wire and you get an opinion, you'll get a published opinion out there on GAO every time. All right. The GAO is pretty good at holding the government accountable. It's, even though they're government employees paid by the government in the government's office, they take very good pride in their job, and they will beat the agencies about the head and shoulders if they think the agency's out of line. So I disagree with GAO's attorneys often. But I respect them, and they all are very good at their job, and they generally will give you a very good reasoned opinion. And sometimes I'll begrudgingly agree with them, even if I lose. They're usually on the ball. So again, we talked about this earlier. You get your agency report. I review the report, and I provide comments and a supplemental protest back to GAO. If there's no supplemental protest, we stop there. GAO goes through the reviews and makes a final decision. GAO can hold hearings. Hearings hardly ever occur. One more war story, because this is impressive. At one point in time, I got to work on what at the time was the largest dollar bid protest ever. It was actually a nuclear weapons manufacturing protest. It was a 28 billion, that's billion with a B, dollar award. We protested. It was a 6-day hearing at GAO. The contracting officer spent 3.5 days on the witness stand. It was that, I will tell you, is an absolute outlier. That's the only hearing I've ever had at GAO for a bid protest. Other hearings that I've seen colleagues or other people deal with usually are a day, if that. GAO, like I said, they'll hardly ever have hearings. It's almost always on the paper. And again, 100 days, GAO will never miss the 100-day deadline, because then they got to tell on themselves to Congress. So protests, are all protests simple? Yes and no, right? It depends on how complex the opportunity is. If you're bidding a $500,000 opportunity, the protest is going to be a lot simpler than if you're bidding a $15 million opportunity, just because the size and scope of the opportunity is going to be more complex. The file is going to be deeper. There's going to be more issues out there, right? The more things you're trying to sell to the government or the government's trying to buy in one procurement, the more complicated it gets. Now, that doesn't mean a $500,000 contract is a simple protest, because you may have a simple ground up front and then you get the record and realize the government made 5 other errors in the process. So, a simple protest is one that goes from, I file a protest letter, I get the record supports my arguments, but no new protest, I file a comments and I go. But at GAO, even the more complicated ones are still fairly simple. They're a factually dependent argument. So if I file a protest, do I get to see the agency's documents? Yes and no. We talked about the record, right? The record will come unredacted to me to see, at least in the protest grounds. If there's 10 bidders and you're protesting the awardee, the only people whose files we'll see is going to be yours and the awardees. We won't see the other competitors. But I generally get to see everything. There are some times, especially in a very factual issue that involves some really complex IT systems or some engineering issues, that I could not even begin to understand the factual evaluation. I can get permission to release redacted documents to my client. So you can see some of this stuff, but very little are you going to see on your own. And if you're a pro se protester, you'll see none of it, because your counsel won't even be in there to argue that you need to see a couple of things. So back one more thing on that last back a slide. So I can talk to you generically about the file. I'm under protective order. If I violate it, I could get barred from GAO practice, so I'm not going to violate it. But I can have conversations with you generically to help you, understand what the government did and how and why they did it. So when you have an experienced attorney who's been through the GAO process a lot, they understand what they can and can't say to you. I really try to do my best to give my clients as much information as I can so they feel comfortable with where we are. It's without violating GAO's protective order. So I don't want to do that. The final decision goes public. It's redacted. So I will see the actual decision. I will propose redactions to GAO to protect your information, whether you're the protester or the intervener. And GAO doesn't usually accept all my redactions, because I usually go overboard just to make sure I'm getting everything I really want. But GAO will redact out a lot, and they'll publish it final. And that's where our bid protest weeklies come from, the published opinions. When you go read them and you'll see deleted within the opinion, that's where they redacted out stuff that relates to procurement sensitive information. if you get a sustained protest, it really depends on what your argument is and what you ask for, right? They can, normally if you're the protester and you were second in line, we're going to ask for a reevaluation, cancel the award. Sometimes GAO will recommend that the award was so screwed up that the agency should throw the whole thing out and start over again. Sometimes they only go back and reevaluate part. Maybe we argue that, hey, they misread my past performance reference and it says X when they said it says Y. So GAO will order them to go back and just do that. Now, here's the big part for you that's really nice, is if you win your protest, GAO can award you attorney's fees, and the agency can have to pony up money to cover your fees. So if you have a good, strong protest argument, we go to the mat and we win, you'll get reimbursed on your fees, and the agency, basically this is structured so the agency doesn't defend bad decisions. All right, it's a little bit punitive to the agency to hit them in the wallet and make their agency counsel go to their boss and explain that they've got to write a check to the protester because they advanced a bad legal argument. So that's a big benefit to winning. So you cannot appeal from GAO. There's no appeal from GAO, but you can bring the exact same protest to the Court of Federal Claims. And the Court of Federal Claims starts it all over again from scratch. Now, can you go back one real quick, Merritt? I know we're running out of time. So you can bring, if you're the protester and you lose at GAO, you can bring the exact same protest at the Court of Federal Claims. If you're the awardee and the protest is sustained at GAO, you can go to the Court of Federal Claims and challenge the decision. You don't challenge GAO's decision. So GAO makes a recommendation that the agency do X. If you're the awardee and GAO says, hey, agency, go back and reevaluate, and you think GAO is out of its mind, you can go to the Court of Federal Claims and you can challenge the agency's action in response to the GAO decision. I had one very ugly protest where we represented Jacobs Engineering against IBM. We lost the GAO, and we went and we challenged the Army's decision to follow GAO's guidance, and we won at the Court of Federal Claims. That was a very big, expensive contract, and it was worth the fight. But it was an instance where GAO is not flawless, and you can go challenge them even if the protest is sustained and you're the awardee. Now, I wouldn't recommend that often. But there's times where that's a way to go to GAO. Next slide, please.
All right, and we're butting up against 12 o'clock. So let's spend about another 3 minutes going through Court of Federal Claims, and then we have a few questions to answer.
Okay, honestly, this we kind of covered already earlier. The slide's a little more detail. We talked about it. No automatic stay at the Court of Federal Claims. You still get an administrative record. It's still protected under a protective order. And you do basically a motions practice on the record. You can try to get discovery. It's frowned upon and not often. Normally, it's normally just like GAO in this aspect. You get a record, you write a brief on the record, the government writes a brief on the record, and the court decides. That's probably, even at Court of Federal Claims, that's probably 9 out of 10 Court of Federal Claims protests, how they go through the process. And again, they don't have a timeline. Depending on their docket, though, it can be a lot faster than 100 days at GAO. But again, because there's no automatic stay and there's a lot of extra filings, it's worth taking the extra time at GAO than going straight to Court of Federal Claims. Yes, it's faster, but a lot more expensive. You can appeal from the Court of Federal Claims to the Federal Circuit, and then you could appeal to the Supreme Court. The first time I touch a case that ends up at the Federal Circuit, let alone the Supreme Court, I will let you all know. Generally, you're not going to make those arguments, and those are going to be, you're going to make those appeals if you're a Lockheed Martin or a SAIC bidding a $400 million contract opportunity. All right, so generally, most most people aren't going to the federal circuit, let alone the Supreme Court. And again, can you win a protest? Absolutely. 50% of the time, you're going to get relief. At least in 2020, you did. You can get corrective action, or you can go all the way to the merits and win. And and again, having written my fair share of proposals, and pouring your blood, sweat, and tears into those things, you want to make sure you're treated fairly. And the biggest thing with a GAO protest is, if you want to make a strictly cost benefit analysis, it's not expensive to bring a GAO protest. If you come to me with a standard protest argument and I need to write a protest letter, and I'm going to get a protest and go to the administrative record, I can generally do that for probably 10 to 15 hours of legal time, which you're talking $5,000 to $6,000 of legal fees. So, I mean, if you're bidding an opportunity that's a couple $100,000 opportunity where you had a chance to make $90,000 or $100,000 or more in profits over 5 years, you can do the math on whether it's worth spending $5,000 to figure out if you were treated fairly. I am absolutely adamant when I get there and I get the record to go to my clients and tell them if we need to withdraw. I don't do myself any favors by, pushing a losing argument on a protest. So, again, how to know when to protest. If you get notified of a government decision, that's when your clock starts ticking. Okay. Always ask for your debrief. We talked through all this earlier. You want to get your debrief. You want to use your enhanced debrief. You really want to talk to an attorney at this point in time and have a conversation about whether it makes sense to protest or not. I will talk just as many clients out of protesting as I will into protesting. And again, here's the key. It's a business decision. I will give you the legal analysis, and then you have to decide whether it makes financial sense to push forward with a protest. How strong are your grounds? Are you incumbent? Are you not an incumbent? Did the incumbent win? Do I have another? The government's not supposed to get mad at you for protesting, and they generally don't. But if you have if you lose bid A, but you have bid B in front of the exact same contracting officer, maybe you don't want to bring a protest because you don't want to tick that contracting officer off. Or maybe you do want to bring a protest because you want to show the contracting officer that you're not going to roll over and let them take advantage of you. So these are all business decisions. I've had a lot of these conversations. When I was an in-house attorney, I had them all the time. I'm in with the operations guys. Let's talk about whether it makes sense. What's the legal strengths? What are the legal weaknesses? What do I gain from a business standpoint? There's times I've advised clients to bring a protest that I think you're going to lose just because you need to prove a point to the government. Maybe it's under an IDIQ contract and you've gotten hosed over 2 or 3 times in a row. So you want to let the government know you're paying attention and you're not going to take it anymore. Sometimes that works. There's a lot of nuanced business reasons around protests, and it's worth having a conversation to discuss them to know whether or not it really makes sense to push forward. Next slide. And when you want to have that conversation, that's how you get me. So again, like I said, I always encourage people to call and talk to me. You don't want to lose a protest ground before you have a chance to bring it. And I jump up and down, and I'm not the only. Every protest attorney out there says this every time they talk in public. Always talk to attorneys, pay attention to your deadlines, do these things. And if you called any one of us, we would all tell you we've had to have conversations with clients because they missed deadlines and they came in too late. So the minute you get that letter that says we're proposing to award to company A, you should be reaching out to me or somebody else to have a conversation about what your options are. So,
great. Questions, but you really answered them as we were going along. So kudos to you, Lewis. So I think with that, I don't see any additional questions now. please consider following up with Lewis via telephone or email. Visit our website, General Counsel Law or gcpc.com. Visit Bid Protest Weekly, and if you need legal help with a bid protest or government contract matters, please reach out to Lewis. So thank you so much.
All right. Thank you.
All right.
Bye.
Bye-bye.